This is the Asset Protection Show. Expert strategies by attorney John Skabelund.
Welcome to the Asset Protection Show, the podcast dedicated to not only protecting your assets from lawsuits and creditors, but also protecting your legacy. After all, what we do isn't just for ourselves, but to create generational wealth. I'm your host, John Skabelund. In the prior 2 episodes, we've covered the top 3 questions each from real estate investors who want to upgrade their wealth and safeguard their assets. Today, we're going to tackle another 3 common questions about LLCs that I receive from real estate investors regularly. To remind you, the prior episodes we covered, do you need an LLC, whether you should buy a property in an LLC, where you should create that LLC, does creating an LLC make you more of a target to be sued, and whether you should create your own LLC or use someone other than an experienced asset protection attorney. Check out those prior episodes if you want to hear the answers to those questions. Today we'll start with the question of what is an LLC operating agreement and are they all created equal? Well, an operating agreement allows us to opt out of the default rules for an LLC. Every LLC is governed by a state's statutes. Those statutes are what we call the default rules. And frankly, those rules are not nearly as strong as they should be. In order to opt out of those statutory default rules, you need an operating agreement. An operating agreement is a contract. That contract spells out the rules and terms between the owners of an LLC, we call them members, the manager of the LLC, that is the person making the day-to-day decisions for the LLC, and all third parties. And third parties would consist of creditors. What rights do creditors and third parties have in interacting with the LLC? Well, those all should be spelled out in your operating agreement. And without an operating agreement, the default statutory rules will apply. So let me make sure we're very clear on that. I get asked all the time, do I need a will? Well, believe it or not, everyone listening to this podcast has an estate plan. They may not like that estate plan. Why? Because if you don't have a will or a living trust and had an estate plan created by an experienced attorney, your default rules, your statutes of your state have created an estate plan for you. And you may not like how those rules are. So why would you create a will or a living trust? To opt out of those default rules in your state. The same thing applies for LLCs. Now, not all operating agreements are created equal. In my career, I have reviewed more than 1,000 operating agreements for LLCs. They vary widely. I have seen operating agreements literally as short as 2 or 3 pages, and I have read 100-page operating agreements. Why is that important? Well, I want you to remember the whole point of the LLC is to eliminate ambiguity in court to the degree possible. We want certainty in court that your LLC is going to be upheld by any attack. Well, that is what the operating agreement is designed to do. It needs to create detail. The more details the operating agreement contains, the less inherent ambiguity. And in litigation, ambiguity is not your friend. You want everything, to the degree possible, spelled out. That is why working with an experienced asset protection attorney who has done litigation is critical, because they've been in the war zone and have been in front of judges. They know where the pitfalls in operating agreements can lie. Speaking for me personally, my LLC operating agreements for a single member LLC are typically around 47 pages long, whereas operating agreement for a multi-member LLC is around 57 pages long. I get asked all the time, why do these have to be so long and so complicated? Well, I ask a similar question. Which part of your house would you like removed? You really don't need that additional bathroom, do you? What about the kitchen sink? Is that really necessary? Yes, it is necessary. So when I create these LLC operating agreements for my clients and they want to minimize it or make it shorter, I ask, what part of this do you not want? Because when we remove anything out of the operating agreement, we're creating more ambiguity. When I explain it that way to the client, now they're grateful that the operating agreement is as detailed as it is and as long as it is. Now, here's where the secret sauce lies for me and my clients. I insert in my operating agreements poison pills. These poison pills is what makes the LLC unattractive to a plaintiff. Meaning, if a plaintiff is successful in taking away my client's membership interest in an LLC, they don't want it. My client, as manager of the LLC, can make life miserable for that plaintiff stepping into the LLC as what is called an assignee. That plaintiff will not have the same voting rights and powers my client has as a member due to the poison pills that I've put in the operating agreement. And that is what the operating agreement is designed to do. First and foremost, prevent a plaintiff from getting into the LLC. And if they are successful, you want them to get out of the LLC. The other purpose of an operating agreement is to make sure that everything is clear between partners. That's what we call a multi-member LLC. If you have more than one owner of an LLC, there's what we call business divorces, business disputes all the time that can take place. We want that operating agreement to make very clear as to what rights a member has and what powers the manager has in operating the LLC. Those all need to be contained in the operating agreement. I'll do a whole episode on operating agreements, what they should cover, and why they are important later. But the moral of the story is this: not all operating agreements are created equal. This is not something you should be downloading from the internet. I've had clients do that, and then when I review their LLC operating agreement and identify to them all the holes and problems in it, they are happy to pay me to amend and restate that operating agreement and do it right. The next common question I get is whether I need a single member LLC or a multi-member LLC, and what is the difference? Well, a single member LLC is when there's only one owner, and that is typically a terrible idea unless that one owner is a holding company LLC. The reason being is a single member LLC is not as strong against plaintiffs in court. The other kind of LLC is multi-member LLC. As I just alluded to in my prior answer to the previous question, a multi-member LLC means that there is more than one owner. And the reason why it's important that you have more than one owner of an LLC is then we have protections against plaintiffs. After all, one of the big distinctions and benefits of an LLC over a corporation is that a corporation simply has shareholders. All of us listening may own stock in Tesla or Apple or some other publicly traded company, but we have no relationship amongst each other. A judge is happy to give away my shares in Tesla to my plaintiff. Why? Because the other shareholders are not harmed. That is not the case with LLCs. In an LLC, we are governed by a completely different set of rules or statutes in every state. There's corporation statutes, and then there are partnership statutes. LLCs are governed by partnership statutes. What that means is that the members are partners with one another. They may have fiduciary duties or responsibilities to one another. If I sell my interest in an LLC to another partner, my existing partner may not be happy with that. And that's why typically in operating agreements, there are restrictions on transferability and being able to sell your ownership. Because me and my partner, we trusted one another to go into business with one another. Well, that operating agreement should protect against someone stepping into the shoes of my partner. And so when a plaintiff comes, we want the ability to have an arm's length partner that the judge needs to protect in LLC statutes against the plaintiff stepping in. And it's for this reason, in the operating agreement, it needs to explicitly say that someone who is not purchasing the membership interest and the LLC and its members are not otherwise approving the transfer of the membership interest should be an assignee. An assignee should be spelled out in the operating agreement as to not have voting rights and certain powers that a member otherwise would have. As you may imagine, the details and terms contained in a multi-member LLC are more comprehensive than in a single-member LLC. But again, you only want to have a single-member LLC if that single-member LLC is owned by a holding company. And ideally, every holding company should be a multi-member LLC. The last question that we'll tackle today is, what about taxes, John? How does taxes work with LLCs? It's one of the reasons why we love LLCs. They are extremely flexible and versatile. So if you only have one LLC owner, the default is that LLC is considered disregarded, meaning that it flows directly onto that owner's personal tax return. When you have a multi-member LLC, the default is that it's taxed as a partnership. However, whether it's a single member or a multi-member LLC, you can elect to have it treated as a C corporation or an S corporation. And that can be confusing for a lot of clients. Because we're taxing the LLC as an S corporation or as a C corporation, they sometimes think that they have a corporation. No, you don't want a corporation. Again, corporations have shares. They are not nearly as protected because the plaintiff can take your shares away from you, whereas a plaintiff should not be able to take your membership interest in an LLC. But you can tax an LLC like a corporation. It can be an S corporation. It can be a C corporation. But frequently, it's desirable that it's either disregarded or taxed as a partnership. And that gets me to a very important point. You never want to be working in a silo. I am a big advocate and believer that you need to always have professional tax counsel that will create a strategic tax plan that your LLC is a part of. If we're not working with your tax advisor, then we could actually be working against your tax strategy. So it's your tax advisor who tells me, as the asset protection attorney, how they want your LLC taxed. And again, that LLC can be taxed as disregarded, as a partnership, as a S corporation, or as a C corporation. Rarely do I have an opinion on the tax status of the LLC as an asset protection attorney. And this is part of the reason why 90% or more of our clients tend to be referred to us from their CPA, because we're creating an asset protection plan that works with the tax advisor's tax strategy, not against it. The last point I'll make is it's critical that your LLCs are structured in a way where they're aligned with one another to reduce and minimize tax returns. As I alluded to earlier, I've had clients that are filing numerous, dozens upon dozens of tax returns for each and every single LLC, and it's simply unnecessary. You can create your LLC as a disregarded LLC, where it flows directly onto a multi-member LLC's tax return, whether that multi-member LLC's tax return is a partnership, an S corporation, or a C corporation. So there is a way to strategically create your LLCs not only to accomplish privacy, making you less desirable in the eyes of the plaintiff, you can actually minimize your tax returns. If you're interested in learning more about how to reduce your income taxes with real estate investing and how LLCs play an important role, I encourage you to listen to episode 2, my interview with CPA Justin Jensen, or episode 4 with nationally recognized tax strategist Tom Wheelwright. Those episodes we cover tax strategy and we discuss LLCs. And with that, we'll wrap up today's episode. Thank you so much for joining me. My goal with this podcast is to give you great, actionable content that empowers you to protect the assets you've worked so hard to build. To help me do that, I would love to hear from you. What topics are on your mind? Are there specific strategies or legal questions you want me to cover? Please leave me a comment and let me know. If you found today's information valuable, will you please consider sharing this episode with someone who might also benefit? Word of mouth is the best way for this show to grow. Finally, if you have a moment, leaving a quick rating and review on your favorite podcast app would help immensely. It only takes a minute, and it makes a real difference in helping others find the show so that they too can learn from an asset protection attorney about how to protect their assets and preserve their legacy. Thank you again for listening. Until next time, stay protected.
You've been listening to the Asset Protection Show. Expert strategies by attorney John Skabelund. For more information, go to assetprotectionshow.com.
This content is legal information only and not legal advice. Viewing this content does not create an attorney-client relationship. Mr. Skabelund is admitted to practice law in Arizona, and he may be reached at ultimateassetprotection.com.